Hello, Alexandra. Thank you very much for joining me today.
Hi, Valeria. Thank you very much for having me. It's a pleasure to see you, and it's a great opportunity to tell everyone a little bit more about myself. Thank you.
Alexandra, if it's okay, I'm going to start by introducing you a bit.
Sure.
Alexandra Wintrebert is the Senior Director at Ankura. She's an experienced forensic accountant and expert with over 9 years of experience in dispute resolution matters. She has extensive experience in providing expert accounting advice in contentious proceedings, and she has acted on a wide range of expert witness engagements covering valuations, loss of profits, breach of contract, and post acquisition disputes. Alexandra appears in the ranking of Who's Who Legal since 2023, Arbitration Future Leaders, and Expert Witnesses France.
Thank you,
Alex,
Valeria.
can you tell us about your career journey and how did you become a forensic accountant?
Thank you so much for this question. It's an interesting one because my career path was not conventional, and usually tell people, depending on their background, is that I have two stories: a long one and a short one. So what I'm going to try to do today is just um, to tell you the longer version, but in a kind of a shorter space of time. I started my career in 2011 while I was studying towards my law degree in London. At the time, I was aspiring to become a lawyer, and that was the way forward. I was very open to very different opportunities during my studies, and I came across an internship which had like a mysterious description. The firm were looking for a number of people who would have extensive language skills to assist them on the high court litigation between two oligarchs. So it sounded sufficiently interesting in terms of complexity of a dispute, and also the language knowledge was something that fitted my profile perfectly. So I thought that I would give it a try. And I was actually fascinated to see how the arguments could be made with figures and with numbers. I only thought that the arguments could be made with words, but I was proven wrong. I was fascinated by what they were doing, and it became a career, and I've never looked back. I never regretted my decision to change from becoming a lawyer and actually becoming a qualified accountant later on. And yeah, it is a career that I thoroughly enjoy.
I think it's super interesting and it's very rare as sort of a career. And I like how you were studying to be a lawyer, and now lawyers are your clients in a way.
Yes, yes, precisely. So, in a way, I know what they're going through. Of course, my knowledge of law kind of stopped at the bachelor's degree level, but still, I think having the legal background is very helpful in my profession. And although it's absolutely incidental that I do have a law degree, it's not how you enter into forensic accounting profession. You would usually start as an accountant with an audit firm, and you would study towards the exams while you practice an audit, and then you would go into forensic accounting. I still think that that sort of critical thinking that you learn during your at the law school is very relevant to what I do.
So you told me that you create arguments with numbers, but can you maybe develop it a bit more on what is forensic accounting, and what exactly does a forensic accountant like you do?
It's a very it's that I'm laughing because I actually had a look online. I was thinking like, I'm wondering how would Google or Investopedia define our profession, and I came across every single time it was the same, the different words, but it's the same kind of definition. And I'm going to quote one. It says a combination of accounting, investigative techniques used to discover financial crimes or utilize skills in accounting, audited, and investigative skills when conducting an investigation. So whenever I've looked at any definition, there was always this financial misconduct angle or a fraud angle. And yes, I agree that as a forensic accountant, you will utilize your accounting, perhaps auditing if you have some background in audit, and investigative skills, but not necessarily just in financial misconduct circumstances. You could use those skills to provide expert evidence on a particular question pertaining in the area of your expertise. So there are two branches of forensic accountants. Some would do investigations, and they would indeed look into accounts to unravel fraud or provide a view whether the money laundering have happened. So is always going to be in that sort of financial misconduct kind of area. But what I do is, and what other forensic accountants like I do, we use our skills in a contentious background or in a contentious proceedings. So when two parties in a dispute cannot reach an agreement on the financial aspect of the subject matter of the dispute, that's when forensic accountants like I am intervene. There is a very good movie with Ben Affleck, if anyone is up for action movie, called The Accountant. It was released in 2016. So if anyone wants to know what we do, except for shooting a sniper rifle and doing a combat fighting, that movie is pretty good. It's a pretty good explanation, actually.
Okay, thank you for this recommendation. I'll watch it on my next movie night as well. When I interview lawyers, I usually like to ask this question of what should go wrong at the client side for them to need your services. I would like to ask a similar question to you. Like what kind of cases need your expertise? Or like what areas of law typically require experience and an expertise of a forensic accountant?
If we will kind of stay at the contentious spectrum of forensic accountants, that's where I fall in.
Yeah.
It could be any commercial dispute in a local court or in international arbitration. Could be things like breach of contract, for example, or a dispute between an investor that has invested a certain amount of money into a state. It could be a dispute between two states. It could be a dispute that arises out of the merger and acquisition deal and something has gone wrong during particular stages of that deal, and then that dispute the aspects of it would be different. So I would say that most commercial disputes would involve forensic accountants, simply because the nature of relationships between the parties was monetary. So whenever there is that monetary aspect that needs to be determined and the parties are in disagreement, which happens quite a lot of time, that's when we would intervene.
And can you maybe give a more practical example on if you can share it, if it's public information, of a case when your expertise changed or influenced an outcome of the proceeding?
I don't want to sound like I want to overplay the importance of my profession, but what I will say next will probably sound like it. It would be very difficult to isolate one case. I think whenever the case gets to a forensic accountant or to an expert, it is because the understanding of a financial side of a dispute is crucial. And if we think about the dispute and the various stages of it, in an essence, what we're trying to do is we're trying to provide a party who's being wronged with a financial remedy. And a commercial party would go into dispute on the reliance of getting that financial remedy. So we could litigate or arbitrate about many things, but the end question is, do I get something out of this? I've already sustained some losses, I've already sustained some damage. If I go into dispute and I continue to sustain losses and damages because I will have to sustain legal and court or arbitration fees. Is there a reward in the end? So damages question, and the question that is posed to forensic accountants and experts, is always very crucial and very important. So I'm sorry, I'm giving you very kind of a vague answer without giving a particular example, but I would just struggle to find one, because every single time there is a kind of a battle between two sides. The claimant side would like to get a remedy in their claim, and the respondent side would like to reduce the amount of that remedy. So necessarily the expert evidence becomes very important for the determining party, meaning the tribunal or a court judge, and for the parties themselves, and for the outcome, because in the end of the day, it's whether you will get X or Y out of the dispute.
I can imagine. Well, it sounds very important and actually crucial for cases. But did it already happen to you to have this opinion of lawyers that maybe they will do it themselves? You know, like maybe they will not hire an expert on this forensic expert on this case, and they will just come up with, I don't know, a number and say that's what that's the damages, that's what they need, or it's really always essential to have a forensic expert on your team when the stakes are high, when the case is complex.
It depends on the issue at hand. If we're talking about, let's say, a contract which had a liquidation damages clause in it, then the matter could be way more straightforward, and the parties actually do not need an expert. But in most instances, when the parties get to the stage when they're certain, like they're 100% going into a dispute, they have tried to mitigate, they have tried various ways of getting to a common ground, and they have failed, it is likely that it is because they're just way apart on various issues, including the financial aspect of a dispute. And to answer your question, whether it happens, yes, it does. Sometimes we see that the lawyers would, during the first submission, they would just put a figure, like a really rough estimate, let's say, a damages in the tune of, I don't know, 100 million. And then with the caveat that this is to be determined by the expert evidence in the due course. So yeah, usually it's sometimes at the kind of a statement of claim stage, very first stage in a dispute. Yes, we're not involved necessarily. But I always encourage and say this, that you can get more out of your expert if you involve them earlier. In terms of seeing representatives of the legal profession trying to estimate damages themselves, I always encourage them to do that, because I think the more you work with damages experts, the more you understand damages better, and the more you have ability to kind of to work on damages yourself. However, we are called by tribunals and by the courts for a reason. We do have a special and necessary knowledge that the representatives of the legal profession might not necessarily have to the same extent as we do. And every case is usually based on like a set of facts, and behind those facts there are tiny details. And our profession is all about details, and the devil is in the detail. And if you don't have the same knowledge as we do, the chances are that you will likely miss those details, and they could be crucial to your case.
So, Alexandra, it seems that you intervene on matters and on cases that are very complex and that have this complex, number side to it. And on top of that, the parties don't agree on probably on anything when it comes to the moment when they are in court. How do you explain complex and difficult details that involve numbers and that they involve complex calculations to the parties involved and to judges?
This is an excellent question. I would probably like to take a step back from the proceedings, from the court hearing or from the tribunal hearing, to where we first start to intervene, where the other side would first see an expert appearing in a case. So I'll be talking here just as an example for. Just as an example, I would use the instance where we would assist the claimant's case. So we'd usually prepare a first report that would be submitted with a first round of statements of claim and submissions from the claimant's side. That report will go to the respondent, and that report would also be submitted to the tribunal. We will then issue a second report, because usually the other side would also engage an expert, and that expert would respond to our report and may not necessarily agree with everything that we're saying and perhaps advance some other arguments. So all we would do in a second report is that we would address those issues. And then hopefully the idea behind the process is that by those exchanges of reports, hopefully the experts will get to some sort of form of an agreement, at least on some issues. Whether that happens in practice, it's another matter, but this is how the process looks like. So actually the communication starts with an issuance of a report. And it is incredibly important to make sure that your points that you're making, you will get them across to your audience. So it's a combination of a use of a particular language that is tailored to your audience. So our audience are lawyers, members of the arbitral tribunal or the court judges. And so the use of language is incredibly important. But we need to bear in mind that the report needs to be practical. So for instance, if you want to make a point and you want to make that point to stand out, then it's perhaps worth bringing it up in an executive summary section. We also use a lot of visuals like graphs and charts, and it is simply because we all different and we digest information in a different way. For some people, it's easier to digest information when they read the text. For some people, it is easier to digest it when you look at the visuals. Some people prefer just kind of a short summaries and, I don't know, maybe a summary tables. And then if they need to dive into the detail of those, they could cross-refer to a particular section of the report and read the whole reasoning behind those conclusions. So every expert report that we produce would be with that in mind. We do not necessarily know in that great detail the audience that we're addressing. Yes, we know the opposing side's counsel, we know who the judges or the arbitral tribunal members are, but we do know how they digest information. So our task is actually, it's not easy, but there are techniques, as I just explained, in order to make sure that that information is being sent in the right way to your audience. And when we communicate complex financial issues, we should bear in mind that the parties that are going to digest that information do not necessarily have the same knowledge as we do. I had one unofficial finance teacher who was helping me during my accountancy qualification, was actually my husband, and he had given me the best advice ever that I keep to myself to date. And he said that if you can explain a very complex concept to a layperson in a simple terms, it means that you completely grasp it. If you can use your own words to explain it without losing an important detail, and that person who knows nothing about finance understands that it's a test, that you have completely grasped the subject. And this is what I try to keep in mind when I draft the reports, or I'm trying to get the information across to the other side, the side that does not necessarily have the same knowledge. And the communication skills, I would go back to them. They also become very important during the proceedings. We are usually, depending on whether it's the court proceedings or the arbitral proceedings, we would get an opportunity to present our case. So we would get 30 minutes or so to present our findings. So again, making sure that you pick the right information and you make sure that you want to address a particular points, that's crucial because you're timed.
Yeah.
And also during a cross-examination, it's a very particular moment. You are being challenged by the other side. So it's very important to stay on track and remember what is it exactly your evidence is about and what is it exactly you'd like to convey to the arbitral tribunal. So communication skills are key.
Mm-hmm. I can imagine, and it must be a stressful moment as well to participate in a court hearing and well to be part of this cross-examination, to be challenged. So on top of being a very good expert in numbers in forensic accounting, you also need to have this very good communication skills to be persuasive, calm, and to defend your case well, almost like a lawyer, actually.
Yes, almost like a lawyer. It is true. You have to know how to withstand and how to excel under stress. You certainly need to know how to do that. Cross-examination is a kind of a culmination of everything that you have done on this case, and that's where it gets to kind of a final point. And yes, the other side will try to challenge your evidence. They will try to challenge your you as an expert. And it is psychologically, it is not an easy moment because you have presented your opinion and for your professional opinion, your objective opinion, and that is being challenged. So it is not an easy moment, but again, it's not something that you cannot do. It just takes some experience to get to that point.
I can imagine. I wanted to ask you, what advice would you give to law firms on how they can best leverage forensic accountants in their cases? So I understood from what you said that one advice is to hire a forensic accountant early enough in the case so that they would get most of your expertise and build a stronger case from the outline. But maybe there is something more that you could say and that you could advise.
Yes, actually involving your expert early would help, not just trying to get the number right. It's also about you can get a lot of help at the document production stage. We know what financial and accounting or internal management information is likely to be relevant, and we know how to word your requests in order to get actually exactly what you want from the other side. So that's another advice that I would give on the top of involving us early. I would say that as a kind of a general advice, I would say that you should listen to your expert, and sometimes in our work we might come across a certain point which might not necessarily be favorable to your case, but the likelihood is that if we have found it, the other side will also find it. So it's better to be warned early than have some bad surprises during the hearing or during the submission exchanges stage. So it's always listen. It's always good to listen to your expert and take the advices seriously. I would also advise to do a regular checkups with them and keep them up to date on any changes, however tiny, in the legal strategy, because we use a lot of assumptions when we calculate damages or when we prepare a valuation model, and sometimes things that might appear irrelevant for the expert evidence to a lawyer actually will not be. And again, we just want to avoid any last minute surprises. So a transparency with your expert is a good advice. Also, if you have any evidence, new evidence introduced, I would also advise to keep your expert up to date on that. It did happen to me that we were not updated on the new evidence, and it cannot say it was a crucial point, but it did backfire during the hearing. I would also suggest to give your expert an access to the complete case file. You might think that there are documents or witness statements or exhibits and annexes that are not necessarily relevant to an expert. But as I explained earlier, our work is all about assumptions and details behind those assumptions. So what might seem irrelevant to you actually will be relevant potentially to an expert, and it will save you a lot of time from getting occasional documents requests from an expert. So it's also like time efficient exercise. And I would also advise to involve your expert in the hearing preparations. Expert could give you a myriad points for cross-examination of the opposing side's expert. And we frequently do that on cases, and it always is helpful. So I think those would be my my kind of main points, which I think is already a lot.
It's very interesting, and it's interesting how you really are a project partner. In a case, you're not just there to do the math right. You're also there to win the case, in a way.
Yes, we get really involved, and the more assistance and involvement from our instructing legal counsel we get, the better it is usually.
From what you're sharing with me, it seems to me that you work with a lot of information when you are on a case, and this leads me to another maybe areas of questions that I wanted to ask you about digital transformation of your sector. So one of the probably new type of technology that is currently transforming legal sector is the AI. Can you tell me a bit more if how is it and what is the role of AI in forensic accounting? Do you use AI? How is it relevant? Tell me more about it.
Sure. It's another excellent question. Thank you for it. The use of various tools and softwares to assist forensic experts is not new. Anyone who's in this profession or anyone who has worked with an expert, particularly on a case which involved extensively heavy document disclosure, would know about OCR software. OCR stands for optical character recognition. Essentially, it's a software that you would get a license for a period of time, whatever is needed for the dispute, and you would download all the data there. And then in order to extract a particular piece of information, you would do searches based on the keywords. And what this OCR software would do is that they would recognize characters on the document, so OCR, optical character recognition, and it will pull out all documents. So for instance, you could say bank statement, and it will pull out every document that has got bank statement written on it. And then you could do your prompts in various ways. So this is not new. This was already on the market at least when I have started in 2011, it was already on the market. But the use of artificial intelligence is actually changing all that. So there are tools which have taken the optical character recognition software to absolutely next level. And at my firm, at Ankura, we use artificial intelligence quite extensively. So for instance, if I were to draw a comparison with the OCR software, we have our own in-house built software that would not just necessarily recognize characters. You could give it prompts and you would want it to extract some information, for example.
So tell me about the tools that you use at Ankura for AI matters.
So we have a Nora GPT, which is the custom state-of-art artificial intelligence generative tool that is used by most Ankura employees on the daily basis. I would personally use it to help me draft emails, to help me to summarize some documents, to help me to prepare a proposal, for example. A good example could be I would download to Nora a complex spreadsheet with a lot of qualitative information. I don't know, a questionnaire that people would give responses to, and they would not necessarily give a yes or no response, but they would provide some sort of description. And you need to summarize that information. So Nora would do that for me instead of me going through every single question. Nora would do that for me. Or, for example, if I receive a very lengthy note on the facts of a case and I need to summarize that in a short and concise form for the proposal, I would just download the document to Nora and upload the document to Nora, and I would ask Nora to summarize the key facts for me, and she would do that. So usually I would spend, maybe an hour or so going through the document myself, and then picking what is key, and then making sure that I summarize it in my own words in proposal. Now Nora does that for me, and it's incredibly helpful. Another tool that I use not on a daily basis but quite frequently is called Nora Notes. It's a tool that helps to prepare meeting notes. And anyone who's been in my profession or in legal profession at the junior stages, and we're all there, knows how many hours you would spend after the meeting trying to prepare the notes. We no longer do that. If we have a Teams meeting, we would ask if we have a meeting with an external party, we would ask for permission to record the meeting, and we would use that recording to upload it to Nora Notes. Depending on the type of the meeting notes that we want, let's say I would like to have a meeting notes that summarizes who would do what and by when. I would ask Nora to do that, and it would take her minutes instead of hours. I absolutely love this tool. It's such a more efficient way of using my time and time of more junior members of the team. And it's always appreciated by clients. They're always amazed at how quickly we give them the meeting notes and how precise those meeting notes are. So those are the two tools that I use on a daily basis.
That's super interesting, and it seems that not only you gain in productivity, but also probably, if I stay in the example of this task that should be very time consuming for a junior and probably stressful as well to get all the information right after a meeting to prepare the notes, it probably has transformed their experience of being a junior professional in the field, because they no longer need to do that. They have tools they rely on for that tasks.
Yes, absolutely. I'm a big fan of artificial intelligence. I think I'm in a camp that thinks that we cannot deny that it would shape our profession. I'm also in the camp that believes that artificial intelligence will not replace an expert, simply because of the complexity of everything that we do. Well, at least not during my lifetime, which is great. So, but I think artificial intelligence still nowadays, no matter how sophisticated it is, it needs to be used with a bit of caution. So if you know what exactly you need out of Nora, you will know how to write your prompt. But in order to do that, you need to have a certain level of experience. You cannot just take I don't know, an arbitral tribunal decision without knowing what the decision contains
Yeah.
and write the right prompt.
Mm-hmm.
So my advice to more junior members of the team is that gain that experience first. Do not rely as extensively on AI, especially when it gets to more complex tasks, like summarizing information, for example, or extracting every single quote that relates to a particular issue in case. Because I don't have necessarily doubts about artificial intelligence ability to do that, but I do have doubts about a junior members of the team ability to write the correct prompt because of the experience.
That's super interesting. You gained in productivity and in time. Would you say that you spend less time on a case overall, or you just spend it differently, or maybe going more in depth on some other questions?
Think that you don't spend less time on a case necessarily, but you would divert that time, that freed up time, on things that are more important. I would probably spend more time on a model, the model that would quantify damages or value a company at stake in a particular case. I would spend more time there. I would spend more time going through the disclosure and making sure that we have picked up on everything that is relevant. We would spend more time on making sure that our work is error-free, and that what we say makes sense from the legal case strategy. So we would spend more time on the on the quality of our work as opposed to just churning out information. And I would add that I'm a young mother, so any freed up time is always appreciated.
Of course, I understand. Do you tell your clients that you use AI?
Yes, we do. Our artificial intelligence tools are available to our clients. I'm not going to tell you all the details simply because I do not know them. We have an impressive AI team who develops those tools, improves them, and markets them to our clients. But I know that the majority of our artificial intelligence tools are available to clients on a sort of custom-made basis. So it could be a short subscription, it could be a lifetime access, could be a license, etc., etc. It all depends on clients' individual needs. But yeah, we do have some clients who have actually acquired some way of accessing our artificial intelligence tools. Yes.
I find it brilliant, but not only you use AI and you leverage your expertise with this technical new technical ability, but also you market it to the client in a very transparent way that they also can pay for it and all, get more access to it. I think it's to me. I'm convinced that this is how it should be actually.
Thank you. I cannot take the credit for that. I think it's something that our brilliant artificial intelligence team have achieved. It's not me, but I agree with you. I think it's great that it's just not something that we keep to ourselves. We give access to it if needed to external bodies, and I think it's a great way of also promoting the use of artificial intelligence and demonstrating how artificial intelligence could be a helper, could be a friend, not a foe.
Thank you, Alexandra. I wanted to ask you some questions about the more practical and maybe business level of your activity. And the first question that comes to mind is, how do you find new clients?
Networking. That's the very short answer to it. It's our ultimate clients usually are various companies, individuals, and enterprises who are parties to a dispute. But the likelihood is that unless you're dealing with a major listed company that the nature of operations is inherently litigious, they would know experts, they would know how experts work, and they would have some firm views as to which experts they would like or would not like to use. But in most instances, you would be dealing with individuals and companies who have absolutely zero knowledge of who experts are, and if they ever know about forensic accountants, it's from Ben Affleck movie. So they would not necessarily have an access to us directly, and we won't have an access to them. Well, it's the legal team and the lawyers who actually will hire us as an expert or will instruct us as an expert. So when we do our networking, with the representatives of the legal profession, lawyers, and yeah, so networking is the key. And the bigger your network is, the better it is for you as an expert. And all our marketing and business development activities are actually built on the idea of networking, and then taking that networking from stage A, when you're getting to know a lawyer, to a stage when that lawyer have enough confidence in you to actually appoint you as an expert on one of their legal matters. And that process could be lengthy. Sometimes you never get there. Sometimes you get there in a very short space of time. But there are various ways of how we get from point A to point B. And for that, we use a lot of BD and marketing.
And can a law firm appoint you as an expert in several cases?
Yes, they can. And we do have some recurring clients coming back to us. If we have done a great job, then there is no reason for them not to come back to us. So yes, it does happen. However, especially in the international arbitration proceedings, some firms might be perceived as using the same expert all the time. And there is a slight twist to it, because as an expert, we are independent. Although we are appointed by the either claimant or the respondent side, our opinion is independent on who we are appointed by. We are not advocating the case. We are presenting the financial side of the case or the claim to the tribunal, and our duty is to the tribunal, and it's actually a very important aspect of our work. So when an expert is appointed by a firm on a recurring and regular basis, there is something that might put into question his or her independence. So firms that we work with would appoint us, but again, we need to always bear in mind that we need to keep this, the independence is a crucial in our profession.
Another very practical question that is very probably like a heated question for lawyers is, how do you price your services? Do you have an hourly fee? Do you have a project fee? Do you work on a success fee? Or can it be a combination of several things? How does it work?
Our pricing strategy is similar to law firms or to consulting firms. We have a set hourly rates that would depend on the grade, starting from the most junior one and all the way up to a senior partner or testifying expert grade. And we would use those hourly rates to, we would bill those hourly rates to our client or to our instructing legal counsel, depending on who our relationships are with. But, and we would price our work depending on our estimate of hours at each level that we need to form in order to produce the desired outcome. And the desired outcome is the first report, second report, and then hearing attendance. However, it is inherently difficult to always have a very precise estimate. There could be various issues with a particular case that might render your estimate as not entirely correct. And it's not necessarily our fault. Sometimes you would get a case where the client thinks that the claim is very straightforward from the damages or the expert evidence perspective. And you actually get to see the data and you realize that there are a lot of blanks and there are a lot of missing gaps in that data, and you need to fill in that data with something. And it turns into an exercise where you spend an extra amount of hours which you have not budgeted for, but you cannot not do that because that would undermine the claim. So, and you could not produce a reasoned expert opinion simply because there are gaps, or the quality of data is unsatisfactory. So it does happen that sometimes your estimate is not entirely accurate simply because there could be issues during the case and the quality of the data is just one example, that might impact on your fee estimate. We usually discuss these issues beforehand with the client. So if we discover that there is such issue, we will always try to be upfront and explain before it gets to the stage when the bill is issued and there are some bad surprises. In terms of a success fee, we have our duty to the tribunal. Our duty is not to our client. This is part of our professional standards and professional ethics. Therefore, we cannot advocate a claim for a client or for legal counsel. And the outcome of our expert opinion could not depend on the outcome of the case, because this is just undermines our independence. So we never work on the success fee. The outcome of our findings is simply not dependent on the future outcome of the claim. So yeah, we don't do success fee.
No, that makes absolutely sense. If you want to have an unbiased expert opinion on a case, then
Absolutely.
you shouldn't be incentivized on its outcome. So you mentioned that the data quality can be one of the factors that can influence the whole project price. What other things can make your services more complicated and so more expensive?
It also always depends on the scale of a dispute and the complexity of issues that we need to consider. It is one thing to look at a company that has got just local operations and the revenues which are not significant. And we know that its accounting and financial or management information is fairly straightforward simply because they don't have the complexity of operations. And it's completely different when you consider a conglomerate or a company with worldwide diversified portfolio of operations. We will be then dealing with a completely different set of information, and the complexity of that information also depends on the issues at hand. So the type of the dispute, timing is also important. because the shorter the time scale, the more hours we will need to put in to make sure that we produce a reasoned and qualified expert opinion. So yeah, I would say that the quality of the information that we touched upon earlier, the complexity of a dispute, the size of the parties, the complexity of the financial records, and the timing are also important. And the complexity would have an impact on how many people you need to have in a team. Sometimes you might work in a small team of an expert, someone supporting that expert, and the junior member of the team. So it's just 3 of you, sometimes even 2 of you. And I could give an example of case that I'm working on at the moment. It's an international arbitration, and we are 7 at different levels. And it's simply because the complexity of that dispute requires that number of people, because it's so big and it includes so many issues for experts to determine that one would be difficult for one person to keep concentrated on all of them. We have to break down the workload into various streams, and every single one of the member of the team would be responsible for a different stream of that case, and have little or very little to do with other streams. So that again, it's because of the complexity and the number of questions that experts need to answer.
Thank you for your answer. It's very, very interesting. How do you work on your visibility as an expert on the legal market? So you mentioned previously that you get new clients by networking. What exactly do you do?
So there are various tools that are available to us, if I could call them that. Networking brings you great visibility simply by going to conferences, attending seminars, and making sure that people see that you're there, you're representing a particular firm, and they know what you do. That gives you a great visibility. But also, like, more, for example, as an expert, you could participate on a panel during a conference and provide your opinion on the topic that is being discussed from the expert's perspective. So we give you visibility in a different way, and it's a different type of visibility. Not only you're present there like you would be during a networking event or a conference, you also give the audience an opportunity to listen to you, so to actually understand how good your communication skills are, and they're very important for experts. And you would also provide a view on something, which is again an important aspect for you as an expert and for your prospective clients to see, because how you present your opinion and what you actually, the opinion that you express, is also very important and gives you that visibility. There are other ways. It's like simple as LinkedIn posts about your activities in the market, what you're doing, where you're going, to conferences, and to more like targeted activities that you could do, including meetings with the lawyers, providing them with some knowledge, sharing your knowledge by giving them a training, for example. Or one of the good examples is like cross-examination training. So you would provide yourself as a kind of a dummy expert and let junior lawyers to practice their cross-examination skills on you. Or you could simply do a lecture on a particular topic that is of interest to them. Loss profits analysis, what's important, or how to calculate the discount rate. And that all in combination gives you a visibility. So it's a complex way of saying there are a lot of tools that are available to you. And I think every single expert would pick and choose those tools that are more accessible to him, because it's not every day that you're that you are invited to participate in a conference. So the tools that are available to you and the tools that you are willing to use because of your personal preferences. But there are quite a few that are available.
No, I think it's very interesting. I think it's interesting how you describe them as this toolbox that you use almost regularly, and waiting that one actually, well, without waiting that they will have an immediate result. And I also find your LinkedIn very insightful and interesting. I always find that the posts that you make don't not only say, "Oh, like I went to this conference," but you always provide a little insight on what did you hear or what were like the key insights from it. As a reader, it's very interesting to
Thank you.
observe.
It's an important feedback. I will keep doing it then. Thank you so much.
So I know that you're also a member of several professional networks, such as the Ukrainian Arbitration Association, the Young ICCA, the Arbitral Women, just to name a few. How do you participate in these networks, and what do they give you?
Each one of those networks are very important if you would like to make a career in international arbitration. It starts with a simple point about networking. Every one of those organizations provides a lot of opportunities to do that. So it is just simple as following up their calendar and finding out what is happening next, what they're doing next, and just simply going to those events and simply networking. So that's the one way. A second way is that you could partner with one of those organizations to do a more targeted event. So, for example, you could partner with Ukrainian Arbitration Association and prepare a webinar on a particular topic that is you think would be of interest to its members, and you would present some form of opinion on a particular matter, and it gives you a lot of visibility. So I think those networks are great. It is also about exchanging information and knowing what is happening with the fellow international arbitration practitioners. So, for instance, Arbitral Women is a great example for that. We would meet during dinners that would be preceded by a panel discussion on a particular topics that are of relevance not just in arbitration but to female practitioners in international arbitration, and then there would be a networking lunch. So you benefit by acquiring some insights and some knowledge about industry and networking. So there are lots of opportunities, and those networks, they have a lot of great features to them that you could use as an expert.
Would you say that personal branding is important in your field of work?
Absolutely, yes. It is very important. As you would progress in your career, it becomes even more important because it is you as an expert who would sign a report. It is you as an expert whose name would be called during the hearing and who would present your findings, your reasoning, and it is you who will be cross-examined. And personal branding is very important. And I think a lot of us do not realize that when we are at the very young stages of our career. But I think it starts there. You by simply doing your job and collaborating with your colleagues, you start to gain a personal brand and you start to gain your personal reputation. You cannot believe the number of times I was able to get some quite correct insights on the opposing experts, but just simply asking around my colleagues people move firms for a number of reasons, and the likelihood is that you have worked with someone that might be now working in the firm that will be acting against you, and they'll know about you. Some people will be able to say, oh, you know, Alexandra, she was good at this, but she was not good at that. And I remember her as a junior, she was, I don't know, such and such. And it's incredible how big, but at the same time small, the network of experts is, and how information about your personal brand and about your reputation that you have acquired internally would travel. You would then continue building on that personal brand as you get more senior and as you start to get more exposure to clients and to lawyers. They would communicate with you, and you would become sort of a conduit between the testifying expert and the client or the legal team. And they would form their opinion on you. And as you grow into becoming a testifying expert, the likelihood is that they'll remember you, especially if they worked on a complex matter with you. So that's a kind of a second stage, and it's also incredibly important. And then obviously when you get to the testifying stage and you provide your report, you give your oral testimony and you're cross-examined, you're not just being observed and judged by the quality of your work. It's not just being observed and judged by your instructing counsel. It's 360. So it is also the opposing counsel. They might say, oh, actually, I do like this expert quite a lot. I should have involved them instead. It's the other side's expert who would, again, if ever comes across me, for instance, they would have an opinion on me because they have seen my reports and they have seen me being cross-examined and testified at the hearing. It's the arbitral tribunal as well. They would look at you, your reports, your evidence, and they will also form an opinion. And all those components would form a part of your personal brand, which is incredibly important.
Thank you, Alexandra. I have a last question for you. What advice would you give to someone who is hoping to succeed in forensic accounting?
Thank you for this question. I really hate to give unsolicited advices, but since you have asked,
It is not this, is it?
I would say that at the first stage, again, when you are perhaps still training to become an accountant, or you studying to become a finance specialist, do your exams well. Not necessarily for the sake of marks that you get and to satisfy your ego. It's because all the information that you acquire during your studies will be very important when you practice as an expert. We touch upon, as experts, we touch upon so many issues. You might get a fairly straightforward claim, and then there's going to be an accounting or like a reporting twist to it, and you have to refresh your memory on your accounting studies. So everything that you study will be very important, and the likelihood is that it will come up during your profession. You don't have to know it outright. You need to remember the concepts. So I would say try to excel at financial reporting, try to excel at business valuation, management accounting, and financial principles and standards. Those are the key. And again, do it for the sake of your future career, not just for the marks. So that's the first piece of advice that I would give. And then the second, I think, is start doing your business development and start building your personal brand as soon as you can. When you are very junior, no one would expect you to go to a conference or to a seminar and bring a client. the expectations are, it's just that you would go there, you meet some people, and these people would form the beginning of your network. And if you do that at the younger stage, it's just a great way of meeting younger lawyers like you are, and then seeing them grow in their career as you do too. And one day they'll become partners, and you would probably become a testifying expert, and you will have that lifelong or career-long relationships. And you do that with your free time. There's no expectations on you winning anything. So just really having fun and meeting great people. So would not shy away from the business development opportunities when you are very young. So I think these are the two key advices that I would give to anyone who wants to one day become a successful testifying expert.
Thank you, Alexandra. Thank you for your time today.
Thank you
Thank
for
you
having me.
that you shared with me.
Thank you so much for having me, and it was a pleasure. And I do hope that the listeners to this podcast would find information interesting and
For sure.
maybe helpful.